termination of parental rights case. One thing I thought about...
If you would introduce yourselves, counsel,
I'm
so it'll be
sorry,
on the record.
I'm Greg Bennett. I'm from the Sevier County Bar.
Yeah.
I represent the father in this case, whose rights were terminated at the trial court.
Yes, sir.
In preparing for this case, one thing that I noted in the many briefs that I have filed before this court, there's always been some standard language that I've always presented. And I think that standard language is the absolute core of preservation and protection of parental rights. And though I don't like to read from my briefs, I do want to read this to the court. This is found on page 23 of my brief. And again, I think it's been in every brief I've ever presented. But it says, terminating parental rights has the legal effect of reducing the parent to the role of a complete stranger, severing forever all legal rights and obligations of the parent. And that's Tennessee Code Annotated 36-113L1. It says, but equally important, terminating parental rights are also forever severs the child's rights to its parents and biological family. The United States Supreme Court has noted few consequences of judicial action that are so grave as the severance of natural family ties. That's MLB versus SLJ, United States Supreme Court 519-102. It was decided in 1996. The reason I start with that is because, again, I believe those are the core protections. Those are the due processes that are allowed to a parent. But at the same time, I'm fearful that sometimes, just like I cut and paste that and put it into my brief, that we tend to cut and paste that in our mind process and we don't give it the true and genuine thought pattern that it deserves. I'll point out, and again, to the extent that the legislature continues to do away with parental rights in termination cases, I would ask that it be incumbent on this court to protect those where they could. Simple as that. The facts involved in this case is DCS received a referral of a home that was cluttered, had feces all over it, and was basically an environmental hazard. They go to the home and do not find it as such. They find the home appropriate. They find that it's clean. But what they do is they drug screen the father, and he tests positive for Suboxone. Father admits that he's had a drug problem ever since the age of 15 because he's been addicted to pain medication due to several accidents or falls, and that when his children were born, he tried to remove himself from the pain medication and started a Suboxone prescription. He presented the Suboxone prescription to DCS. However, the prescription that he presented was not in date, and therefore he, in fact, was using an illegal substance at the time the children were taken into custody.
Didn't he also test positive for methamphetamine?
Not on the first test, Your Honor. He tested positive for Suboxone. Thereafter, every other time, he did test positive for methamphetamine. But the father maintains and has always maintained that he doesn't use methamphetamine, hadn't used methamphetamine, and it is incumbent on DCS to prove their case by clear and convincing evidence. I've cited in my brief the requirements if you're going to terminate an employee for an illegal substance, the requirements that the law requires in order to do that. If we truly believe that terminating parental rights is one of the most grievous things that we can do, then should the father not be afforded at least the same requirements that it requires to terminate you from your employment when you're discussing whether or not you're positive for methamphetamine? The father admitted that he took 3 different kinds of allergy medications, and as I pointed out in my brief, neither I nor him are toxicologists. We're not experts in the field, but to the extent that he always denied it, I would expect that DCS would have a stronger burden to prove, in fact, that he was using methamphetamine throughout the course of the custodial period.
Did the trial court make a credibility determination as to the father?
He did, Your Honor.
And it wasn't favorable?
They did, and it was not
favorable
positive.
to the father.
It was not positive.
Other than a positive test for meth, what proof could DCS present? In other words, if the parent comes in and says, nope, I'm taking these over-the-counter allergy medicines, that's why the meth test positive. I mean, what is DCS?
That's the only explanation the father had to offer.
I understand, but what proof could DCS offer to counter that?
They could have taken those samples, hired a toxicologist themselves, and identified the fact that this testing either could eliminate those over-the-counters or cannot eliminate those over-the-counters. That was never done. To the extent that wasn't done, there's always going to be that question as to whether or not father's positives, meth was false positives, or whether they were not. So I would ask the court to consider, but equally important, moving on to the best interest factor. This is a case where the father and his two children had a very good relationship. Everybody had testified to that. When you look at the best interest factors, DCS did not offer a single witness to identify any of the best interest factors as being in the best interest of the children to terminate the parental rights. In fact, the kids had been in, at the time, DCS custody for approximately 2 years. They had been in 4 different placements. At the time, they were not in a pre-adoptive home. The only criticism they had of father is he was not visiting regularly. However, at the same time, they had the children placed approximately an hour and a half, 2 hours away from the father. The father did not have transportation. He had no way to get there. DCS candidly admitted they made no efforts to try to help father exercise his visitation. In fact,
Did father call the kids?
I'm sorry?
Did father call the kids during this time where he says he couldn't get there? But
The answer is, at one time, father had bought one of the children a phone, and they were FaceTiming together, but of course that violates DCS policy and procedure.
weren't there things found on that phone that were inappropriate?
No, what they found on the phone, yes, I think they did, but they never linked that to the father. They just simply, that the child had presumably found something and put it on the phone. But the problem is, even that effort, which again, I understand it failed to meet the requirements of DCS, but even that effort was pulled away from the father and his kids. Likewise, the DCS worker admitted. She said, we made no effort to try to help the father. And at one point she admitted that telling the kids that it's her father's fault, or their father's fault, that he wasn't visiting. He had the right to visit if he wanted to, but didn't have to. Thereby, again, creating more of a bridge between the father's and the children's relationship. But other than that issue, DCS failed to prove any of the new 22 grounds of best interest.
Well, the continued positive test for meth kind of fits in there too, doesn't it? The best interest.
If everything falls upon the positive test for meth, yes, you could fit that into some of the categories. But for the positive testing for meth, none of the grounds are proven.
Was he offered random drug screens?
He was offered drug screens. He took drug screens. He failed to take one drug screen, I think is what the record reflects. Not that he refused to take drug screens all the time, but he failed to take one drug screen simply because, as he testified, he couldn't get there.
Just one?
I believe it's just once. But again, he tested positive for all of his drug screens for meth, a substance that he claims he's never used. And by the way, he did not test positive one time during the wintertime where you would expect you wouldn't need allergy medicine. That's my time. Thank you.
Thank you, Councilman. You have your time for rebuttal. We'll hear from the appellee.
Good morning. My name is Wade Barnett from the Attorney General's Office, and I represent the appellee, the Department of Children's Services. In this case, the juvenile court terminated father's parental rights based on 4 grounds and found it was in children's best interest to terminate father's parental rights. The department today would ask this court to affirm the juvenile court's ruling. The father's main argument on appeal is that the department did not prove by clear and convincing evidence that that father used methamphetamine. Respectfully, that's not the department's burden. The department's burden is to prove by clear and convincing evidence that that at least one ground for termination exists, and that it is in the children's best interest to terminate father's parental rights. Regarding father's methamphetamine use, as with all other facts, it is to be proven by preponderance of the evidence, and it is incumbent upon the juvenile court to take all the proven facts, put them together, and determine whether DCS has met its burden. Specifically, in this case, the evidence supports the juvenile court's finding that father used methamphetamine. When the children were placed into DCS custody, father did test positive for Suboxone, and he also did test positive for methamphetamine, which was the reason why the children came into DCS custody in the first place. When asked to explain his positive meth results, father gave 2 excuses. He said that he had taken his cousin's medication, and then he changed his mind and then said, I faked my drug screen and I grabbed it from the toilet. Then, at the dependency neglect hearing, father stipulated to substance abuse. Then, over the following 3 years, father continued to test positive for methamphetamine. And then, father continues to deny that he used methamphetamine to this day. However, the record does not support father's argument. Specifically, one example is that on April 8th, 2021, father filed an emergency petition for custody, and in paragraph 4, he stated that he had ceased using the suspect allergy medication. However, 2 weeks later, father had a hair follicle test, and it tested positive for methamphetamine, and the amount was greater than 10,000 picograms per milligram. The record fully supports father's use of methamphetamine. Which leads to the grounds of termination. The DCS moved for 4 grounds for termination in this case: abandonment, failure to provide a suitable home, substantial noncompliance with parency plans, persistent conditions, and failure to manifest ability to parent. After the children came to DCS custody, DCS created 3 permanency plans. The goals were meant to address father's substance abuse, father's relationship with the children, and father's ability to take care of the children. In order to assist father with his efforts, DCS offered drug screens, alcohol and drug assessments, mental assessments, and participation in the Youth Villages pilot program. However, despite DCS's efforts, father did not reciprocate those efforts. Father was required to maintain sobriety. As referenced earlier, father continued to test positive methamphetamine. He was required to provide suitable housing. However, his drug use and denial of drug use prevents his home from being a suitable home. Further, the home that he resided in was not his own home, it was his mother's home. And the only evidence of the home as it currently stands is in Exhibit 27, which depicts the computer room where the children resided before they were placed into DCS custody. That room is messy, has open food, and has a pet rat in it. This is also the room that law enforcement found a mirror with white powder and straws in the closet when the children came into DCS custody. The other issue with the home was that there was evidence that other people were living there outside of DCS's knowledge. In December of 2021, The DCS caseworker went to the home and a family came out that was not the mother or father's brother. And DCS had no record of them. And when that woman came out, her driver's license listed the Butler Street address on there. Father's stated plan, if he were to regain custody, was to return to Pennsylvania. However, his plan is that he would attempt to find a job similar to what he had at trial, which was at Texas Roadhouse, and then, if that failed, rely on welfare. However, Father does not have a home in Pennsylvania anymore. When he was in Pennsylvania, he lived at his aunt's house, and she has since rented it out to a third party. So Father would have no employment or housing in Pennsylvania if he were to return. Father was required to have visitations. He often canceled visits or visited late, and at one time he was 55 minutes late. Further, he failed to visit the children for a period of 6 months. He failed to visit from September 2021 to March of 2022. Even then, Father tried to explain that he lacked transportation. However, Father made no efforts to secure a reliable transportation plan. He did not own a vehicle. He had a learner's permit, but he allowed it to lapse because he does not like to drive. And he never asked DCS for any assistance with transportation. The only evidence they had of reliable transportation was his testimony that his mother's friend would assist him. However, she did not testify at trial, and there's no other evidence that she would be able to suit his needs. Father was required to pay child support and have a legal income. However, Father made only 3 payments totaling $820 during the entirety of these proceedings, and his last payment was in May of 2021. He admitted at trial that he was subject to contempt as a result of his non-payment. Further, he had inconsistent employment. And all these facts demonstrate that there's a substantial risk of harm to the children if they were returned to the father's custody. The children love Father, but they have realized that he is not improving, and they have been in DCS custody for approximately over 3 years at this point. And even though they had not been placed in a pre-adoptive home at the time of trial, the plan was to put them into a home by the end of the school year. Which leads to the best interest for the children.
Counsel, I mean, the plan was to put them in a pre-adoptive home.
Yes.
I mean, was there any proof other than, did he go into any detail other than just a statement, the plan is to put them in a pre-adoptive home?
There is nothing in the record regarding where the children's placement would be.
Nothing like we have one lined up or we have some in the works, but just that's right. Our plan is to put them in. Okay. Correct.
That was the plan at the time of trial. It is not in the record, but the children are currently in a pre-adoptive home. Which leads to the best interest of the children. They have been in foster care for over 3 years at this point, and Father has not improved. He has continued to test positive for drugs, and he's denied his use and has continued to put the blame on other things. To keep the children in limbo for any longer is not in their best interest, and they need to be able to move forward. Father has failed to demonstrate that any continuity or instability in meeting the children's needs. He's failed to provide more than token support for them. He stated at trial that he did not know their clothing sizes. He stated that he stockpiled gifts for them for 3 years, including video games and video game consoles. But when the children asked for them on 2 occasions, he gave the excuse of, well, I forgot them, or they're in a separate room and I don't have access to that room. Father also demonstrated memory issues at trial, including he did not remember the children's ages, and he also forgot that he had visited the children a week prior to the termination hearing. He had their last visit with them on April 12th, 2022, but in the trial hearing was on April 20th. He had forgotten that he had visited them from that point in time. All these facts, and most importantly, father's continued drug use and denial of it, demonstrate that all 4 grounds for termination exist by clear and convincing evidence, and that is in the children's best interest to terminate father's parental rights. And with that, that concludes my argument. I'm happy to take any questions the court has for me. Otherwise, thank you.
I hear none. Thank you.
Thank you.
We'll hear from the appellant rebuttal.
Your Honors, as far as the father's ability to take care of the kids, in fact, one of the grounds is that he failed to manifest the willingness or ability, but for the time that DCS entered his home, he was taking care of the kids. That inspection of the home found the home to be safe and appropriate. The kids said at that time they felt safe in the home itself. Father relied on Social Security. Father relied on welfare. He relied on SNAP programs. He relied on all the assistance he could possibly get from the state of Tennessee, or prior to that, the state of Pennsylvania. He's not alone in that regard. Many parents rely on that to keep their stability. But the truth of the matter is, the father had stability. The father had demonstrated an ability and a desire to care for his kids. There was a tremendous relationship between him and the kids, so much so that he snuck a phone into with one of them that DCS didn't know about, because father couldn't travel an hour and a half, 2 hours to get to the kids on visitation on a regular scheduled time. You know, this link between the father and the children was tremendous. So we're down to one point. And that point is, was there methadone use? We can say the father's house was messy because we did a video chat once and we saw, a room that was in clutter behind him. But the day they went in to inspect for the children, they found it appropriate. One other DCS worker had gone into the home during the interim time. She found the home to be appropriate. The only testimony was, we're looking in a video at a video chat, and we see clutter behind the father. And somehow we're going to determine that that caused the home to be inappropriate. Likewise, the argument and allegations that the police found a white powder in a mirror, that's nowhere in the record. That's an allegation made by DCS. That is not an allegation that's ever been proved or substantiated by any court order or by any offer of proof by anybody.
And let me ask you to respond to opposing counsel's point that the facts have to be determined not by clear and convincing, but that each fact has to be determined by preponderance of the evidence. And then you look at that universe of facts and decide, is that clear and convincing evidence? So the argument that you're making, that whether or not the father continued to use meth had to be proven only by, that fact had to be proven only by preponderance of the evidence. Do you agree?
Your Honor, I would agree with that. That's why I started my argument the way I did.
And you don't think, so it's your position that the preponderance of the evidence is otherwise? On that fact?
My position is on that fact, though it may or may not have risen to preponderance of the evidence, DCS had an obligation to this family, not only the father, but to this family, to take further steps to either determine that, in fact, there was methamphetamine use or that there was not. The problem is DCS has a whole pool of money available to them. They use that whole pool of money to do parenting assessments, mental health evaluations, things of that nature, things to try to determine whether or not the parents can be fit. They don't use that money appropriately to help the families reunite as they should. In this case, it would not have been difficult to get a toxicologist on board to determine whether or not, in fact, what the father had in his system was allergy medication or simply or methamphetamine. And I think that by failing to do that, we have failed this family.
Did the father stipulate to a finding of dependency and neglect based upon his substance abuse issues?
Yes, sir. Yes, but again, the reason for that is the father claims that he had a expired Suboxone prescription, but he was still using Suboxone from the expired prescription. Totally different
He also
issue.
tested positive for meth prior to that.
But apparently, I was mistaken about that. Apparently, he would have been, but at the same time, would that have been any different than the allergy medication he continued to test positive for?
All right, thank you, counsel.
Thank you, Your Honor.
Court's thanks to counsel for both sides. We appreciate your arguments and your briefs in this. Thank you.